Major decision from the Supreme Court that could have larger implications on gun laws. Nationwide will allow scrutiny for all gun laws pertaining to everything assault weapons, age restrictions on magazines. This is big topics ranging from gun rights and private property laws to foreign property confiscation. It also puts state laws in jeopardy that are similar to this law. It conflicts with the Second Amendment's right to bear arms. It's a case that legal experts will be watching closely. A 6-3 vote just changed the entire landscape of American firearms law. Not slightly, not incrementally, completely. If you own firearms, or if you simply believe constitutional rights mean what they actually say, then what just happened at the Supreme Court affects you directly, regardless of which state you live in. The framework that's governed gun regulations for decades has been dismantled and replaced with something fundamentally different. This isn't about politics or preferences. This is about precedent, and it ripples through every concealed carry law, every training requirement, every background check system, and every permit process currently operating in this country. The Supreme Court's 6-3 ruling landed like a seismic event through every layer of firearms regulation. At its core, the case examined whether states could force law-abiding citizens to prove a special need or endure indefinite delays before exercising a right explicitly guaranteed by the Constitution. The court's answer was unequivocal: no. In delivering that answer, they reinforced and significantly expanded the 2022 Bruen precedent, which established that all gun regulations must align with America's historical tradition of firearm ownership. The decision effectively made constitutional carry the national standard for lawful citizens. Any law that demands proof of personal necessity now stands on extremely unstable legal ground. The court used historical practice as the definitive test for whether modern regulations can survive constitutional scrutiny. What this means in practical terms is that bureaucratic permission systems can no longer be deployed to burden fundamental rights. State officials cannot treat the Second Amendment as something different from or lesser than the First Amendment or the Fourth Amendment. With this decision, the Supreme Court reminded every legislature and every agency that this constitutional guarantee is not conditional. It's not a privilege granted by government. It's a permanent right that predates government itself. This ruling represents the collapse of what's known as Mayus issue permit systems. Before Bruen, states like California, New York, and New Jersey operated under frameworks where even if applicants passed comprehensive background checks and completed all required training, local officials could still deny permits based entirely on subjective discretion. That era is effectively ending. The ruling dismantles the discretionary authority that allowed officials to pick and choose who gets to exercise constitutional rights based on personal judgment rather than objective standards. New York's good cause requirement, which let officials demand applicants prove they face specific threats before being allowed to carry, has effectively collapsed under this precedent. California's model of allowing local sheriffs to approve or deny permits based on their individual assessment of an applicant's character or need is now under serious constitutional review. Hawaii and Maryland's highly restrictive approaches are facing direct legal challenges. Courts examining these systems must now evaluate them against historical analogies from the founding era and the period immediately following the 14th Amendment's ratification, not against modern policy preferences or contemporary political concerns. States that continue clinging to subjective approval systems are facing a legal countdown. They must fundamentally rewrite their laws to comply with this constitutional standard, or watch those laws get dismantled piece by piece in federal court. For gun owners, this means your rights should no longer depend on what county you live in, or whether your local sheriff personally approves of civilian gun ownership. The Constitution doesn't change based on geography or the political preferences of local officials. For years, states opposed to gun ownership used time itself as a regulatory weapon. They would stretch permit approval processes for months, sometimes 6 months or longer, to discourage applicants and reduce the number of people who would complete the process. That administrative strategy is now under direct constitutional fire. The court has ruled that the right to carry is active and immediate, not something that can be indefinitely postponed through bureaucratic delay tactics. Federal courts are increasingly treating excessive permit processing delays as direct violations of the right to bear arms. States that routinely drag applications out for half a year or longer are facing injunctions compelling them to process permits within reasonable timeframes. Federal lawsuits have already been filed in Illinois, Massachusetts, and several other states specifically targeting these delay tactics. Judges are fast-tracking compliance orders that force states to process applications promptly rather than using administrative inertia as a de facto denial mechanism. The timeline has become a new constitutional battleground. Every day a lawful citizen who meets all legal requirements is kept waiting is now being viewed by courts as a day that person's constitutional rights are being denied. And under this new president, that simply will not stand. The administrative state can no longer hide behind processing backlogs and bureaucratic inefficiency when fundamental rights are at stake. Training for firearm safety is genuinely important. Nobody disputes that. But governments have long used mandatory training courses combined with prohibitively high fees as hidden barriers to exercising Second Amendment rights. The Supreme Court has now examined whether those conditions can legally restrict access to carry rights, and they've signaled clearly that they cannot. Modern training mandates are being tested against what existed during the founding era and the decades following the Civil War. Courts are systematically rejecting laws that have no equivalent from the 18th or 19th centuries. States like Maryland, Connecticut, and California are facing direct scrutiny of their training requirements. Some of these states mandate up to 16 hours of classroom instruction, live fire demonstrations, multiple range sessions, and courses that can cost upward of $1,000 when you factor in fees, ammunition, and range time. These requirements are being challenged as excessive barriers that transform a constitutional right into a privilege accessible only to those with significant time and money. This doesn't mean firearms training loses its importance. Responsible gun ownership absolutely requires proper education and practice. What it means is that government cannot transform safety instruction into an obstacle course designed to discourage exercise of constitutional rights. States can encourage training. They can provide free training resources. What they cannot do is make training requirements so burdensome that they function as effective prohibitions for working-class Americans who can't afford to take multiple days off work or spend hundreds of dollars on mandatory courses. The ruling also didn't abolish background checks, but it placed new constitutional limits on how they can be implemented and used. The court made clear that the background check process must be fast, accurate, and non-punitive. Delays caused by technical errors, system failures, or indefinite pending statuses now risk violating the Constitution itself. The National Instant Criminal Background Check System typically completes checks within minutes, but the law allows sales to proceed after 3 business days if the check hasn't been completed. Some states have attempted to extend those waiting periods or layer additional state-level screening systems on top of federal checks. Those extended timelines are now under legal review. States that have created parallel screening systems requiring separate state background checks in addition to federal ENX checks face constitutional challenges, arguing those systems represent redundant bureaucratic barriers. Gun store holds, based on vague suspicion rather than specific disqualifying information, may be ruled unconstitutional. Waiting period extensions in states like California and Washington that add days or weeks beyond federal requirements are being reevaluated under the stricter constitutional standard. The court's message is straightforward. Background check systems must verify actual legal disqualification quickly and accurately, or they must step aside and allow the transaction to proceed. Justice delayed is now being treated as rights denied, and the burden is on government to justify every hour of delay. One of the most significant constitutional questions this ruling addresses concerns authority and control. When state laws directly contradict the Second Amendment, who has final authority? The court's majority made that answer unambiguous. Constitutional rights are national. They do not stop at state borders. and they cannot be diminished by local preferences or regional political cultures. States that continue enforcing highly restrictive gun laws are now facing immediate federal injunctions. Federal courts are prioritizing challenges to state statutes that conflict with this new constitutional framework. Even federal agencies, including the Bureau of Alcohol, Tobacco, Firearms, and Explosives, are being evaluated through the same historical tradition lens that the Bruen line of rulings established. Any government entity, whether state, local, or federal, that attempts to narrow Second Amendment protections will face strict judicial scrutiny moving forward. This represents more than just a power shift between state and federal authority. It's a constitutional rebalancing. For decades, states like California, New York, and New Jersey have systematically tested the limits of how far they could regulate firearms while still claiming to respect the Second Amendment. Now, those same states are discovering that the federal judiciary is standing firmly in opposition to regulations that cannot be justified by historical precedent. The 2022 Bruen decision was already recognized as a major turning point in Second Amendment jurisprudence. But this new ruling transforms Bruen from an important precedent into foundational doctrine. Every Second Amendment case going forward will now begin and end with what's being called the Bruen test. Does the challenge law align with America's historical tradition of firearm ownership and regulation? If it doesn't, it fails constitutional scrutiny. This ruling strengthens Bruen significantly by making historical justification an absolute mandatory requirement. States can no longer defend gun control laws based on modern crime statistics, contemporary public safety arguments, or current political concerns. Courts must now look directly to the original public understanding of the Second Amendment as it existed when it was ratified and as it was understood when the 14th Amendment extended constitutional protections against state infringement. The result is a dramatically higher legal bar that will likely invalidate countless restrictive laws nationwide. Laws passed in the last few decades based on evolving interpretations of what the Second Amendment supposedly allows are now being measured against what the Second Amendment actually meant to the people who wrote it and ratified it. This decision has created a new era of constitutional analysis. Bruen is no longer just one standard among many. It's become the backbone of judicial review for all firearms regulations. Any modern rule that lacks direct historical roots will struggle to survive legal challenge. The impact of this ruling won't be confined to courtrooms. It will ripple through state legislatures, federal agencies, and advocacy organizations across the entire country. The national conversation about gun rights has fundamentally shifted from whether constitutional protections exist to how far those protections extend. Lawsuits have already been filed in more than a dozen states using this decision as their legal foundation. Pro-Second Amendment states are moving rapidly to expand permitless carry laws and strengthen preemption statutes that prevent local governments from creating patchwork regulations. Meanwhile, states that have built their identities around strict gun control are regrouping, searching for new regulatory strategies that might withstand constitutional challenge under this much stricter historical standard. The Bureau of Alcohol, Tobacco, Firearms, and Explosives will find its future actions, especially regarding firearm classifications, accessory regulations, and enforcement priorities, watched closely and challenged aggressively under this strengthened constitutional framework. This ruling is not the conclusion of debates over the Second Amendment. It's the beginning of a long legal and political campaign to rebuild the practical meaning of constitutional gun rights around their original historical form. The Supreme Court has drawn a clear line. The battles ahead will determine who has the resolve, resources, and persistence to defend that line in legislatures, courts, and the court of public opinion. For decades, lawful gun owners have been playing defense, responding to new restrictions and regulations one at a time as states and localities pass them. But with this ruling, the ground has fundamentally shifted. The burden of justification has moved. Government must now prove its case using historical evidence, not policy preferences. The momentum that favored expansion of regulations has reversed direction. What comes next will depend on how aggressively this precedent gets applied and whether courts at every level follow through on the constitutional principles the Supreme Court has now established. That's it for today, folks. See you in the next video.